Item number 17, my lord.
7.
Only password this month after the day, my lord. English law, as Islam, yes, out of instruction, my lord. Our mother is serious.
Yes.
Pray for listing matter on Friday matter.
When did you file?
No matter, it's a pending matter. Maintenance, I am for the wife, not getting maintenance more than half an hour. Friday matter.
Okay.
I make to mention for listing of a criminal petition on Thursday or Friday.
When did you file?
Just filed in 7th of January. It is already ongoing.
Okay, on Friday.
Friday.
May I please, Your Lordship? Your Lordship, I beg to mention one for listing one bail application, Your Lordship. Co-accused bail is fixed on 28th, Your Lordship.
When did you file?
Your Lordship, it is pending, Your Lordship. Under for hearing.
Give the number.
I have mentioned the number, Your Lordship.
May I please, Your Lordship? Lordship, I may be allowed to withdraw item number 19, Your Lordship.
Just wait for a few minutes. After the mention is over, we'll pass it.
Absolutely.
So Lordship, it's a criminal petition pending and for the disposal, urgency for disposal, it has not been listed.
Can you give us the number?
Criminal petition 9898/2024.
9898
/2024. Last order was 30/10/30.
30.
Maybe it's a lordship. I beg to mention item number 11, lordship, with the consent of the opposite party. Lordship, I pray for adjournment a week.
Let it, date may kindly be fixed, otherwise 11th of June.
Let us see.
Lordship, if it can be fixed any day after 1 week, it will be.
On 10th of June or 11th of
The
June?
week commencing from 2nd, it is full. So it can be considered either on 9th or 11th.
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 Hello, please.
May I please, Your Lordship? Lordship, I beg to mention for withdrawal, my lord. Withdrawal of a criminal.
Tomorrow.
Tomorrow, my lord. Oblige it.
Yes.
May I please, Lordship? Lordship, I beg to mention item 24, Lordship. Lordship, today we have some problem. Difficult with Lordship.
Item number 21?
Yes, ma'am. Yes, ma'am.
Yeah, please, Lordship, I beg to mention item number 40, Lordship. CD is not received, Lordship. Kindly
Which
adjourn.
police station?
Pan Bazaar Police Station, Lord.
When is the last order passed?
It's been
When is the last order passed?
14th of May, Lordship.
Yes, CD not received.
When?
My lord, on
Lordship, kindly fixed on 29th.
29 May. 29, my lord, on 3rd of June, my lord.
29th.
3830.
Yes.
Oblige it.
Without fail.
Yes.
Get it?
May I please, brother? My lord, item number 43, may I have instructions to withdraw the petition?
Wait for a few minutes.
Yep.
Wait for a few minutes.
Okay.
May I please, Your Lordship, I beg to mention for listing of a criminal petition 108 out of 2022. Matter may be listed on whitelist, Your Lordship.
On 3rd.
May I please, lordship? Lordship, I beg to mention item number 1414. I am praying for an adjournment for the day, lordship.
Okay. Okay.
May I please, Your Lordship? Lordship, I would like to mention item 50 and 51. LCR is received, but it is not tagged with record. So matter matter may be fixed on 28 with record. Wait.
28, I won't. Look at it on 20th, along with the relevant records. Call providing. Okay.
Oblige.
May I please, Your Lordship? I beg to mention for listing of regular bill, Lordship.
When did you file?
23. File number 48.
3830.
May it please, Your Lordship. Well, item number 13, my lord, it's a motion matter, my lord. I am not pressing, my lord.
Just a minute. The other mentions will work. We'll take care of it.
May it please the Lordship. Lordship, I seek your permission to go through the records of item number 32 and 55, my lord. Bail hearing matters, my lord.
And 55
Yeah, 32 and 55 minutes, 55 something,
in presence of an additional public person.
deeply obliged, Lordship, please.
Any mention?
I'd like to mention item number 33.
Hmm.
I want to withdraw this, Lordship.
Okay, hold on.
Yes, 33.
Sri Martin, Doctor.
It's a criminal petition, my.
33. Item number 30.
13.
13 is yours.
Yes, ma'am. Yeah. He has been shown as a.
Dr. Counsel appearing for the petition and Mr. Sachin, additional public prosecutor. On instruction of the petitioner, Mr. Doctor, Learned Counsel, not placing this criminal petition in special NDPS case number 39 within bracket N/2024, arising out of NCP crime number 15/2023. To which languages of different objections stands this was being objected.
At this stage, ma'am.
90. Are watching WASI. That's some instructions, same. Not pressing this criminal petition. Praying for passing of the proceeding of the case number 20/2022, pending the 44th of our judicial notice the first class report. It's bill application filed by the petitioner, particularly the petitioner number, petitioner number to be. Kajigaon Police Station case number 21/023. Sorry, special POCSO case number 157/2024. Arising out of Kajigaon Police Station case number 20/024. In section 376(3). Under section 6, we get PTV. Under section 6 of the PSCSO. Ending before the court is on it. Special judge POCSO from additional session judge. Project. So some. Whereas bill application. Regards the petitions. Support Police Station case number 21/2025. Under sections 118 within bracket 2/3 within bracket 5/3/51 within bracket 2. /351 within bracket 3 /109 within bracket 1. PNS 2023 corresponding to GR number 79/2.
Public.
Please, regular bail petition order. Kindly provide the testimony of the lawyer for papers, my lord. In connection with NDPS case number 24 up to 20.
The records of NDPS case number 24, public 2024. Arising out of the RPS case number 207/2023. Pending before the court of learned special judge NDPS come. Session Judge. Kamrup Metro Bond. List on, as on 35 April. Seventh of, 11th of.
Knowledge.
May I please, Your Lordship? 483 application, Your Lordship.
Special NDPS case number 9 of the
Given being all
ending out of non-NDPS case number 1. From the Port of London, Special Judge NDPS, Construction Judge, Kamrup Aminda.
Do you number item to know?
11th of.
May I please, Your Lordship? Lordship, in this case, Lordship, it is a charge-sheeted case, Lordship, and I was arrested on the strength of NVWA issued by the trial court, Lordship. And today, I am already 37 days behind the bar, Lordship. I'm a lady, Lordship, and I have 2 minor children, Lordship. Already 37 days behind the bar for not being appearing before the trial court, Lordship. So,
File an appropriate application instead of bail, because the other application that you can consider, on bail application, you have to get the record.
I annex all the orders.
Even then, we have to call for it.
For that may be given, Lordship. It is only from Kamrup Metro, Lordship.
You should have filed other application.
Lordship, I
I
have
think
filed.
that would have been better for you. Here it is, eligible stamp copy of the records of NDPS case number 08 of 202. Learning out of something without this by something. That's. Report of London Special Judge NDPS. From Session Judge. Metro County. 3005.
Lordship, may I pray for date, Lordship?
11th.
Lordship, kindly before Eid, Lordship.
That cannot be considered.
Kindly, Lordship.
May I please order? The regular bail petition, Lordship. Accusation under section 77-78 subclause 2 of the BNS.
Records of Sessions case number 36 of 2025. Arising out of Miscellaneous PS case number 06 of 2025. Pending before the Court of London Session Judge. Sonnet 2 Judge Court. 35, 11. What is the petition with? Yes, Mr. Borgia.
My lord, the co-accused has been granted bail, my lord. Lordship, kindly have a look the last page, my lord.
Do you have, whether the record was called for in that case?
Lordship,
idea,
it does
Mr.
not reveal so, my lord.
No, that's why we wanted to.
It
know
is,
whether record was-
Lordship will see page 50, my lord, operative part. It does not reveal, my lord, whether the record was called for or not. Basically, my lord, Pravi Purkaisto and Bahan, my
No,
lord.
but there has to be a record first. Just a minute.
Lordship, kindly have a look.
अपना item number किमान है तो?
Pass. All accused have been enlarged on bail, my lord, except me.
Oh, yes. Okay. First page itself, para 3. List on. Hmm. 29. Along with the records of. Bill application number 37872024. Disposed of in 01052022.
Lordship.
For the-
For motion, my lord. Lordship.
Yes. Yes.
Eight people, but I have instruction to withdraw this application.
What's your good name?
AK Khan.
You click on Mr. I Waterfall. On instructions of sentence. Pressing this. Section of Brazil. Case number RR/33/213. Dated 13/04/2025. In the section 9/39/50/57 of the Wildlife Protection Act 1970.
Diary may be called from K3PS month.
If you do it. Yes, from Petri, when,
On 5th of June, well.
okay. Petri PS case number 39/2022.
Nothing over. CD with.
Time of that.
Whether this is NDPS matter under section 2015, where the petitioner is in jail till 664 days. Okay? And on the earlier occasion, bail order was being rejected, but the ground hearing has been taken in regards to the recently concluded case of the Vian Kumar versus State of Haryana and Prabir Gupta.
Application number 906/2025. Disposed upon 13/05/2025. Second of June.
Lordship, within a NDPS case, Lordship, CD will be required.
Records of special NDPS case number 24/2020. Along with the records of Sonai police station case number 137/2019. Court of Learned Special Judge. NDPS chart. Medical person judge. Number 3. Special judge NDPS Kachanili. Special judge NDPS committee session judge number 3 Kachan as on 30/0. Welcome.
Obliged.
Item number 9.
May it please your Lordship, in this case, your Lordship, the accused petitioners are shown as absconders
and non-bailable warrant of arrest has been issued against them by the judicial magistrate Rongia, Your Lordship. We are ready to appear in the trial, Your Lordship. Unfortunately,
When is the
if
next
we
date?
appear-
When is the next date?
Sorry, Your Lordship, I do not have that name.
You have to tell us
Yes.
first, then only you can consult. Day after tomorrow.
Deep, Your Lordship.
Made PG looks. Lordship, this petition is filed seeking custody of the case seized by the police on the last 2 days. The Lordship was pleased to call for the status report from the Tinsukia police station.
Yes,
Prayer
we
for
have this
Jinma report.
status-
My lord, I will get the instruction, my lord, after some time. My lord. Right. Whether report is received or not, my lord.
This is my lord, quashing of DV Act case, my lord. My lordship will see, initially 498A was filed. And thereafter, my lord, I will take your lordship to the first to the impugned order, my lord, page 34, my lord, of the DV Act, my lord. Notice was issued, my lord. This was filed on 21/1/25, my lord, and they were living separately since 16/8/2021, my lord. Now, lordship will see first that FI was lodged by brother-in-law on 17/12/2019, page 71. On 17/12/19, the FI was lost, page 71, lordship may see. That this was registered under 498A, page 71 and 72. Then, my lord, they are acquitted, my lord, on 25/3/2021. Lordship may see that order, my lord, at page 76. Two witnesses are present and they have been examined, PW and PW was prosecuted and discharged. Prosecution evidence is closed on the prayer of the learned APP, and the accused persons are examined under section 313 CRPC. Their pleas are of complete denial and they decline to adduce defense evidence. Heard arguments advanced by learned counsel for both the sides. Judgment is prepared in separate sheets pronounced in the open court and tagged with the case record. The accused persons, Shri Partha Buddha, Srimati Pompa Buddha, Srimati Krishna Buddha and Srimati Sampa Buddha are acquitted of charge offences under section 498A 34 IPC and set at liberty forthwith. Prosecution miserably failed to prove the guilt of the accused persons. Thereafter, again, a case was lodged, my lord, on 16/8/21, page 81 may be seen, my lord. Page 81, my lord, annexure 7. This was lodged by the FIR. Then again, my lord, complained about dowry torture, my lord, and they have alleged that the little finger of that victim was, my lord, broken, my lord, and this was investigated. And finally, my lord, lordship may come to page 88. Final report has been submitted by the police, my lord. Page 88, my lord. Charge sheet, my lord. Sorry, FR. I'm reading the page 89, my lord. During the investigation, page 89, my lord. During investigation of the case, examined the complainant as well as available witnesses and recorded their statement under section 161 CRPC. The victim was sent to JMCH Johar for medical examination. The PO was visited and a rough sketch it was drawn after thorough examination. The accused persons, Path Buddha, Pampa Buddha, Krishna Buddha, Champa Buddha, Nirmala Buddha, and Tabu Buddha were interrogated and then their statement was recorded under.
Which annex you are reading?
Oh, annexation, my lord, sorry, annexation 8, my lord, page 88. That is a second FIR under 498A, and second FIR was lodged under 498A and 325 and 506.
Now, whether this report was accepted?
No, it is now being sent to the court, my lord. Till date, I have no information. I don't know, but FR has been submitted, my lord. Now, lordship may see the maintenance application, my lord. The court has passed the order, which is at page 90, annexation 9. There, the court has ordered, my lord. Lordship may see the order at page, my lord, 96, the operative portion of the. That is the maintenance application, my lord. The order starts from page 90. And ultimately, the court has granted to pay 16,000 maintenance and 50,000 litigation expenses, my lord. That is at page 97, my lord. The order is at page, my lord, the detailed order is page 10 also, my lord. Oh, page 99. Annexure 10. The petitioner then finally filed a criminal petition, my lord, and that is page 102. Then this sum has been reduced, my lord, 13,000 to 4,000, as lordship may see para 10.
Assisted by Ms. Lisa, counsel hearing for the petition. Petition. Also, for the opposite party. Number 1 sledge. Petitioners are agreed. As a land petition, you instead showing put this. I have taken cognizance of the offensive under section 3 of the take that inside. The protection movement to conflict 2005, so summons to them. In case number CR 24 of the 2025. Referred by the Opposite party number 2. Why appropriate petition in the loan? Mr. Roy, senior counsel. Place that. Earlier, the opposite party number 2. Yeah, really. In Jorhat Police Station case number 3528 of 2019 under section 498. Allegations being on behalf of the opposite party. The court of London. Judicial Magistrate Jorhat. Judicial Magistrate. Case number 2 by order 25-032-031 in PRC number 178 of 2020. Acquitted in the charge of offenses under section 498 in the of 34 acts. Subsequent to that, another FIR laws against the petitioners with regard to the assault and violence on the opposite party number 2 being Jorhat PS case number 1773 of 2021, in which the police, after completion of the investigation, submitted final report within the Procedural report on 24/05/2022 white 471, white final report number 470, which is yet to be accepted by the land judicial magistrate. In the meanwhile, pursuant to the orders of the court, as well, the court of London District Judge Jorhat, in this case number 24 of 2023. For judgment dated 18/04/2024, allowed interim maintenance to the petitioner, to the interim maintenance to the opposite party number 2, directing the petition number 1 to pay an amount of rupees 16,000 per month, with litigation cost of rupees 50,000. However, Mr. Roy,
Right. The High Court interfered with that order, my lord, at page 102.
no one appeared for the respondent.
Yes. After receipt of notice also, they didn't appear, my lord. And finally, my lord, the operative portion of the order is from para 10, page 104. But they have not come against that order, my lord. In fact, they have now gone for DV Act case, my lord, after this order. The DV Act case was filed on 15/8, sorry, 16, my lord, 16/8. 16/1 to 2025, they filed the DV case, my lord.
Next date.
And the main claim is that to get money from the other side, my lord. And they are living separately, my lord, since 16/8/2021. And divorce also been filed, my lord, that is on
The-
31/8/2021.
The coordinate bench of this. Order that 110/2024. First name CRP is 29/5/2024.
Next date of the case is fixed on 29/5/25.
Deducted the interim interest to rupees 4,000 per month. Payable to the opposite party number 2. And directed the petition number 1 to pay the litigation expenses in 82 installments at rupees 6,250. Arranged. Addition to the above, the petitioner was directed to pay rupees 3,000 to the opposite party number 2. Whenever she appears before the trial court in battleship in bracket line number 91 of 2031 at court. Pressing all those. Mr. Royal and Senior Counsel declaring for the submission of something. Proceeding outside DB case number such and such pending before the court of London, judicial magistrate first class. That door happened.
The DVS filed at Tejpur, my lord.
At page two, judicial first class at page 4. Against the petition should be set aside in court. Issue notice. Returnable by 19th of June. President of Social Security additional public prosecutor matters, if not be something half of the opposite party number 1 informant of this be issued. Petitioners also to the extent by tomorrow. Petitioners shall take steps for service of notice. The opposite party number 2. Forwarding a direct and for on our report by tomorrow.
By tomorrow.
The interim, the protection paid for by the petitioners shall be considered on the returnable debt of producer which notice and the opposite party number 2.
Next date is on 29th, my lord.
Bring it to the
This
notice.
coming 29th.
Bring it to the notice of the court, nothing. We consider on the notice. Let the service be notice.
And the lordship then give some protection 29th, my lord. They have to go at Tejpur, my lord. That's why, my lord.
Ask someone to appear, Mr. Roy, you know very well. In the other matter, we have seen that there is no mention that notice has been served upon the opposite party number 2. Going to the order. Anyway, it doesn't matter.
They have not come against that order also, but to the High Court, my lord.
Doesn't matter.
And they are living separately
Let
since.
the notice be served, we will consider the returnable.
Thirteen to the. Zero to.
1.5.
13 to withdraw করলাম
Are you in 15?
15
15.
13 14 9 no 14
Yes, Mr. Deori.
Your Lordship, I'm challenging the cognizance that is taken by the magistrate against me, Your Lordship. Your Lordship, may kindly produce the FIR. The FIR at page 15, Your Lordship. The relevant portion is page 17, Your Lordship. May I read? Page 17, Your Lordship. Most respectfully, I beg to state that without my knowledge, some unknown persons had built a tin house and a fence in a plot of land which is located in village Laupani, Bisoynimu, that I own the process. I came to know that the process had been carried out to illegally grab the said land by putting on the banner of a voluntary organization, namely Puberun. I had finished all the work required to fence the aforementioned area of land so that farming could be done there. I am unable to comprehend why they are acting in such a manner when all the documents with respect to the aforementioned land are in my hands. Hence, I pray that you may kindly adjudicate upon the aforesaid case. Now, Your Lordship, after investigation, the final report was submitted, Your Lordship. At page 22, may I read, Your Lordship? Page 22.
মই কেইটামান কেইটা খাব লগা আছে
Or Mr. P. Council appearing for the petition. Petitioners. And Mr. Chief of the Prosecutor appearing. Opposite party number one split. Petitioners are agreed by the order at the 30-8-2024. Passed by Learned Subdivisional Judicial Magistrate within bracket M, Kodia, Apapa. In CR number 03/2024. Arising out of Roykwa Police Station case number 15/2018. Corresponding to GR case number 179/2018. Initially on the basis of an FIR lodged by the opposite party in the court before the officer in charge of 0 Point Ola Police Station. Police Station case number 15/2018 under section 447/34 and which is radio section 5 of the Assam Land Grabbing Act was registered against the petitioners. After completion of the investigation, police in say affair number such and such submitted the final report within the procedural on 31/03/2019 by the final report number 09/2019 against the same the petitioner against the same the complainant / opposite party number 2 submitted a protest petition on 01/07/2024 in GR case number 179/2018 arising out of say choice for PS case number such as as desired within bracket M support for. After considering the said protest petition of the opposite party number 2 dated 01/07/2024 registered with a complaint case being CR number 03/2024. And after taking reference of the two witnesses of the opposite party number 2 / complainant. By order dated 30/08/2024 to cognizance of the offences under section 115 within bracket 2/329 within bracket 3/324 within bracket 4/126 within bracket 2 BNS 2023 against the accused petitioner and summons to them for their appearance in the said CR case number 03/2023. Issue notice returnable by 24th of June. Call for the legible scan copy of the records of Soika Ghat PS case number 15/2018 corresponding to GR number 179/2018 along with the legible scan copy of the records of CR case number after the records of CR case number 03/2006 from the court of Subdivisional Judicial Magistrate within bracket M, so the support. petition of this petitioners are directed to take steps. As such and such. On the respective. As such and such. Accepted notice on behalf of the opposite performance of its by more or opposite party number two. It's the post. The interim pair of the petitioner shall be considered on the returnable date. On failure of the 11 records that has been called for from the court of law and legal justice.
Obligation.
Yeah, please. This is for Jimma of a vehicle, my lord. About Jimma was rejected, has been rejected by the letter court below.
Any report?
Yes,
First of all, we consider that.
Yes, ma'am. Otherwise, your lordship may kindly peruse page 17, my lord. I would just like to point out, my lord, why the trial court has rejected, my lord. In view of section 6E, my lord, paragraph 4, page 17, my lord, paragraph 4, my lord. In view of section 6E has been
Considered.
only the collector and this.
What are the materials seized from the vehicle?
Material says, my lord, at page 11, my. That has been distinguished by this honorable court, my lord, in number of cases. This para of page 17 has been distinguished in number of cases, my lord, when it cannot be granted, when it can be granted.
Heard Mr. Zebang, counsel appearing for the petitioner and consideration of the prosecution representing for the state. Call for the detailed report. From the officer, the investigating officer of Disney Police Station, case number 15 of 2025.
I got it.
What is the ZR case number? Any idea?
Here is reasoning.
Clarifying.
Hmm?
It's 10. Pertaining to Jimma. Of the vehicle bearing registration number AS01AL5320. Renting on Jimma. With the petitioner.
Yes, number is not.
Pertaining to vehicle.
Yes, also not.
C is number. In said NDPS case number 15/2025. List on 18th of June. Copy of this order to Mr. Satan.
Yes.
Mr. Pine, serve him an extra copy.
Yes,
So that he can.
May please, your lordship. Lordship, the calling for MBW lordship, and the complaint is filed in the year of
When is the next
2020.
date?
Lordship,
Where is the next date?
next date lordship on
Get it Thursday.
lordship. Lordship.
Every lordship. Lordship, I may be allowed to withdraw the instant criminal petition, lordship.
Item number 20 call.
19. 20%.
19 has already been withdrawn, I think.
Is it withdrawn? 3 February.
Please, your lordship, the petitioner is aggrieved by the order dated lordship 34/2025, passed by the learned JMFC Sibsagar lordship. Kindly peruse order dated 34/2025, page 30 lordship. Annexure D lordship. Lordship, in this case, what had the magistrate lordship, without examining the complainant and the witnesses lordship, passed this order lordship, which is a total violation of section 223(1) of the BNSS lordship.
Just a minute.
He has neither examined the complaint nor the witness lordship. In this regard, I want to place a judgment lordship, recent judgment lordship. The Kerala High Court lordship.
Heard Mr. P. Borden. Counsel appearing for the petition. What is the next date?
Next date is lordship 19/6 lordship. The last date was 22 lordship, that time
That is the reason we are asking.
lordship, before, after filing lordship.
And Mr. Saputo, client by the prosecutor appearing for the state petition also. Opposite party number, respond number 2, first. Agreed by the order dated 30/04/2025.
04.
First, 2025. Passed by Learned Judicial Magistrate First Class Sibsagar. In CR case number 30/2025. Taking cognizance of the offences against him. Taking cognizance for issuing notice to them without recording the statement of the witnesses by the magistrate of the complainant and his or witnesses by the learned magistrate. The petitioners have filed this criminal petition. Issue notice returnable by 16th of June. As such and such and such, no formal response to the person number 3. No formal response number 2, no formal notice. By community. Petitioner shall accept for some notice on the response number 1. By registered post authority, providing her correct and provided to the persons by the number. Call for the legible scan copy of the records of
CR case number.
Sibsagar Police Station case number 75/2024. Corresponding to the case number 177/2024. The records of CR case number 32/2025. From report of Judicial Magistrate First Class Civil Servant. Director Judicial, list according to law 1606.
Lordship, till then, Lordship.
The interim pay of the petitioners shall be considered on the retirement condition 16/6. Developed the guidelines.
Oblige, your Lordship.
May I please, Lordship, the petitioner hearing challenging cognizance order in a NIA case and proceeding as well as.
What is the order?
Order is at page 10, I think. It's a cognizance order. No. 11, page 11.
Pardon, Mr. B. Who contains the very for the petitioner. It is the prosecutor or less than 1. Agreed by the order dated 17/03/2023, passed by Learned Editorial Petition Magistrate Archer. In NI case number 142/2021. Taking cognizance of the offense of the section 138. This being agreed by the the petition has filed on the complaint filed by the respondent on 0208 2021 030202. The petition. The file. Criminal petition. This is notice. Returnable by. When is the next date?
Next date, next date in month of July. Not exactly, no. But it is fixed on July, as I know.
Later, 23rd of June. All for the issue scan copy of the records. Go to the petition. Such no problem. Impact. Petition is subjected. Some question transfer number 2. Where more date correct. What is corrected. All for the issue scan copy of the records. And I case number 142 of 124 for the petition is petition as in 30/05/2025. List according to your register petition.
Interim pay will be considered
on the returnable date.
Made bigger office. My lord, this is an application under 482, wherein the petitioner who has been implicated and has been charged by an order of the Learned Trial Court, which is put to challenge, my lord, and the FIR has also been put to challenge, including the charge sheet, my lord. Now, my lord, the order your lordship would find at page 71, wherein, my lord, the Learned Court below was pleased to frame charges against the current petitioner, who is serving currently as the branch manager of HDFC Bank, my lord. May I take your lordship to page 71? My lord, the relevant portions, my lord, starts from page 73, my lord. The Learned Court below, on the basis of, my lord, the forensic report and, my lord, the opinion given by the experts have found that there are prima facie case against the current petitioner as well, my lord, which the findings is at page 74, my lord. I have carefully gone through the opinion submitted by the Director of Forensic. The opinion reveals that the person who wrote the blue enclosed writings and signatures stamped and marked as S1 to S25 did not write the red enclosed signatures similarly stamped and marked as Q1 and Q2. It has not been possible to express a definitive opinion regarding the authorship of the red enclosed signatures stamped and marked Q1 and Q2 on the basis of comparison with the supplied standard materials. After examining the entire material, especially Exhibit A reveals that the concerned bank has put a seal as signature verified and customer signed in my presence. It appears that the allegations brought by the prosecution prima facie shows that there are indeed incriminating materials available against the accused persons being part of a conspiracy, which can only be adjudicated on trial. At this stage, the materials available indicates a prima facie case being made out by the prosecution side, and this court is not inclined to discharge the accused person. Accordingly, the prayer made to discharge the accused person stands rejected, my lord. Now, but charges against the persons, my lord, so and so. Today, my lord, the petitioner before your lordship is Srimati so and so, my lord, Abhishuti Goswami, my lord. And shall be framed under section 120B, 420, 468, and 471, my lord. Now, before your lordship, my lord, goes to the merits of the case, my lord, I would just like to give a brief background of this particular case, my lord, how this current petitioner is not even remotely connected. She, at that relevant point of time, was serving as an operational manager, and her post demands that she only acts as a supervisor, and the persons or the employees who are below her, my lord, would scrutiny and would verify the documents, applications that falls, and then thereafter, my lord, it will come to her table.
Just a minute.
Yes, yes, sir.
What is the order?
My lord, order is at page number 71, my lord. And it just 7.
Yes.
Yes, my lord. May I take your lordship to the FIR because a bare reading of the FIR demonstrates that there is a rivalry, or I should say business rivalry between the informant and the main accused person there. And my lord, the petitioner has not been named anywhere in the FIR, my lord. Secondly, my lord, the FIR has been lodged at such a belated stage, knowing the informant very well that he had all the informations pertaining to the whatever transactions he has stated in the FIR, my lord. If I may quickly take your lordship to just some of the main points, which shows that this FIR is nothing but a concocted and afterthought, just to wreak some vengeance upon the main accused, my lord. And unfortunately, the bank officials has been entangled in this mishap, my lord. So, my lord, may kindly come to page 50. I'll just, before page 50, I'll just mention one thing, my lord, at page of 46, my lord. At page 46 of the FIR, the occurrence of the offense, they have mentioned the informant on 26/2016. This date is very important, my lord. The occurrence happened on 20/06/2016. FIR was lodged on 30/11/2017. Almost after, my lord, 4 months. Now, why I'm submitting this, my lord? My lord, may I take a lordship to the main part of the FIR, my lord, now? Page 50, my lord. It is dated 30/11/2017. So, my lord, I'll just skip the first part. It which shows that they had a business relationship. Second paragraph is very important. Although I was an employee in the aforesaid firm, the dealings were carried out in my name. Your lordship has found one. So all the dealings were carried out in his name by the main accused, Sri Lukuram Prajapat, wanted. However, he made me open a new bank account in HDFC Bank, Bhangaghar, Guwahati on 29/7/2015 by current account number such and such, in the name of Anjana Distributors. In the meantime, business of Anjana Distributors was absorbed completely by Sri Agency and my employment was terminated. So his employment was terminated and his partner took over his business, the main accused, my lord. But the papers and the documents, this is very relevant, but the papers and the documents and other properties relating to the business of Anjana Distributor, that is of the informant, including the aforementioned bank account that were kept by Mr. Lukuram Prajapat, were not returned to me in spite of my several requests. So he admits that all the documents pertaining to that bank account was with this main accused person. Consequently, I filed 2 applications. Now, this application is what here he has mentioned the date of occurrence is 26, my lord. He files an application on 26/2016, my lord, to HDFC Bank requesting to make the account as no debit account and to cancel all my signed and unsigned checks, my lord. Now, next your lordship will come. Meanwhile, without informing me, the bank officials changed the registered mobile associated with my associate account number with the another number of Mr. Lukuram Prajapati. Now here, my lord, I would just like to pause, my lord. In this, my lord, the informant has stated that he has basically, number has been changed, but this change of number was done online. It cannot be done physically, my lord. So if it has been done online, change of number has been requested. So he admits that all the password logging ID was with the main accused person. So it was through this main accused that this number was changed, my lord. Bank officials now not having any obliged duty to inform that his number has been changed, my lord. So I'll come to that particular part of the evidence, my lord, a little bit later. Now, my lord, we kindly come on 9/8/2016. This date is very important to make me lift the no debit status of my account. Mr. Lukuram Prajapati credited rupees 3,40,000 only and asked me to withdraw the same by lifting the no debit status. Accordingly, I withdrew the amount and paid it to him by making an application dated 9/8/2016 for lifting no debit for the single transaction enclosed. So he makes this application on 9/8, he lifts this no debit and he withdraws the money, 3,40,000, and he takes and gives it to the main accused person. After that, what happened, my lord? He now starts making allegations. Failing in their design to defraud me, so far as Lukuram Prajapati and others forged my signature and made a counterfeit seal in an application dated 28/8/2017. This is the main bone of contention, my lord. 28/8/2017 is the main application, requesting the concerned bank to remove the ban on debit entry in the said account, which the bank officials obliged as they were also part of the conspiracy to defraud me. On the very next day, they withdraw an amount of 4,80,000 via a check bearing number 00011 from the said account. Here also, my lord, I will place that this amount was never debited from his account by a check. It was rather transferred online. And I have submitted the online transaction records showing that this 3,40,000 was himself transferred to the account of this informant, my lord. Now, my lord, may kindly come. On the same date, Lukuram Prajapati also applied for issuing new checkbook. He admits that his partner has applied against the said account through net banking. Now, my lord, he is coming to this point. Through net banking, and bank also instantly issued a checkbook as desired by Lukuram Prajapati on 29/8/2017. On the very next day, checkbook was sent through courier name so-and-so, by consignment number so-and-so to the address of Anjana distributors, which do not exist at that time, with the phone number of Lukuram Prajapati. According to the POD, the parcel containing the checkbook was received by one Nipendeka on 6/9/2017. The checkbook contained check bearing number 111-135. It may be noted that I have also filed an application on 26/9/2017. This is very important, my lord, to the HDFC Bank for closure of my current account and via acknowledgement dated 26/9/2017. Now, the main part comes, my lord. With my forged signature and counterfeit seal, a check dated 12/09/2017 via check number 112 of 45 lakhs. My lord, this is the most important part of the entire episode, my lord. When on 12/9, a check was deposited worth 45 lakhs, was drawn in favor of Eastern Agency, that is the main accused, by the accused person. It was presented 3 times to the said bank to get away with the money that could have been deposited by me during this time. However, the said check was returned dishonored due to insufficiency of fund in every time. This was done by so-and-so Lukuram Prajapati under a conspiracy, collaboration, and partnership with bank officials, including the concerned branch manager, so-and-so RM, and Miss so-and-so. Petitioner has not been named anywhere here, my lord. Thereafter, a notice. My lord, kindly note this part. Thereafter, a notice dated 15/11/2017 demanding the payment of 45 lakhs as check amount was sent to me. Now, as the check was bounced, my lord, of 45 lakhs, the main accused has given him his notice on 15/11/2017 that you either clear the amount 45 lakhs or he will be taken to the court under NI Act, my lord. And that case is also pending. Now, for this particular act, my lord, for this particular 45 lakhs, where a legal notice was sent, the informant, in order to cover the entire episode, subsequently on 30/11 makes this current FIR, my lord, because he will have to now cook up a story. He will have to now basically make an arrangement to show that the check, whatever was issued in his name, was actually a wrong check. And therefore, on 30/11, he lodges this FIR just to cover up a case and make a case in the NI Act and under the NI Act, my lord. Now, my lord, last paragraph, your lordship says, the fact stated above shows that a conspiracy among the accused persons to defraud me fraudulently, dishonestly using the forged signature and counterfeit seal as genuine to make me part with that property. Accused persons also dishonestly practicing deception and so, my lord. The facts above will establish, my lord. Now, nothing here in this particular FIR shows any kind of involvement of this current petitioner, my lord. Now, police, after investigation, during investigation, examined as many as, my lord, 7 witnesses. And the current informant has also deposed under section 161. Under his deposition also, my lord, he has not stated a iota, he has not made an iota whisper against the current petitioner regarding her involvement, my lord. Then, my lord, this current petitioner had applied for PRS bail. She was granted bail, and the order of bail is at page 56. Now, your lordship may kindly come to the charge sheet, my lord. The police finally, after investigation, for the first time, found that current petitioner was some way on, but they have not, my lord, mentioned any, my lord, relevant materials on the basis of which the current petitioner has been implicated, my lord. Kindly come to page 65, my lord, of my petition, my lord. The charge sheet, my lord. Here, my lord, under the column, my lord, name and address of the accused sent for up for trial as serial number 4, serial number 2 is the current petitioner. For the first time, she appears, my lord. Serial number 2. And then the name and address of the witnesses examined. Well, I have mentioned, my lord, 7 witnesses have been examined. Now, kindly, my lord, see the contents of the charge sheet at serial number 7. The brief description of the complaint is that the officer in charge, Bhangagar, received the complaint on 30/11 from one complainant, namely Ashok Kumar Jain, and registered a case under section 420, 468, 471, 406. My lord, here just I would like to pause, my lord. Till the case was registered, 120B did not come into play, my lord. So 120B was missing. So it was very important for the prosecution or the IO to establish first 120B in order to implicate the current petitioner, my lord. Now, after that, and the case was entrusted to ASI so-and-so investigation. Accordingly, I conducted and completed the investigation accordingly. During investigation, visited the place of occurrence, my lord, and examined the complainant and the witnesses along with HDFC bank officials about the case and recorded their statements, seized some documents from bank and also from the accused Lukuram Prajapat. On going through the documents, it was found that the complainant and the accused Prajapat started a business in the name and style of Anjana Distributors, but due to loss incurred by the said Anjana Distributor, another firm named the Eastern Agency, standing in the name of the accused Lukuram Prajapat, was given the charge of looking after the business of Eastern Anjana Distributors, and complainant was working as an employee of the said firm. The accused Lukuram Prajapat was using the bank account in the name of Anjana Distributors held in Bhangagar to the HDFC Bank. So it is admitted position that accused was using the bank account, main accused was using the bank account of the informant. In the meantime, complainant was given dues against the work done by him, left the job. But the accused person, by putting signatures in a pad of Anjana Distributor and in collusion with the officials of the bank, grabbed 4,80,000. This 4,80,000 has been transferred to the amount to the account of the main accused. My lord, I'll bring the document. From where did the IO got this information, my lord? It's very difficult to say. The complainant, after reopening the HDFC Bank, standing in the name of Anjana Distributor, withdraw a sum of rupees 3,40,000 and thereafter submitted a written application to HDFC Bank for making the account as no debit. But the accused Lukuram Prajapat submitted another application on 28/8 before the bank for reopening the said account by forging the signature of the complainant. Though the application was submitted for transferring the money to the account number so-and-so of the accused person from the complainant Anjana Distribution, but the account transferred to number so-and-so. In connection with this case, madam, this is important. The signatures of complainant Ashok Kumar Jain and accused Lukuram Prajapat were obtained along with the application in the pad of Anjana Distributors containing the 4 signatures of the accused were sent to FSL Kahalipara to obtain expert opinion, and after obtaining expert opinion, it is found that the signature of the complainant contained in the pad and the question signature of the accused sent to the forensic laboratory are not matching, my lord. Then your lordship will turn to the next page at page 67. In connection with the case in hand, employees of the HDFC Bank, HDFC Bank manager, so-and-so, employees of the HDFC Bank, namely so-and-so, 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 along with Raport and Deka, were arrested. During, this is very important, my lord, without giving any reason, without giving any ground, they came to this conclusion simply, IO. During investigation, it is found that employees of the HDFC Bank, namely such and present petitioner such and such, knowing fully well the application submitted by Lukuram Prajapat was false. It would have been false, my lord. In league with Lukuram Prajapat helped him to grab 4,80,000. During investigation, the case against arrested Lukuram Prajapat, Sangeeta Medi and so was found proved under section 420, and for the first time 120B comes into light, and this charge sheet is submitted before this honorable court for trial against the accused person. My lord, the just paragraph above that, IO basically mentions that the application submitted by this gentleman, the main accused, is a forged document that the bank employee should know. Basically, what he's trying to say, that the bank employees who scrutinize the document should know that the application submitted by this particular gentleman was a forged one. Now, my lord, present petitioner is at a higher ups of the, my lord, current bank. She was the operational manager, my lord. At that grassroots level, my lord, it is received by an employee who is in the subordinate level and scrutinizes the signature video records and then forwards it to the other officials. And finally, it is the petitioner who gives the approval. Now, here, my lord, in order to establish 120B, I find it, my lord, there's nothing to show how they have linked me, or there was meeting of minds, my lord, or any act or conduct in which, my lord, the police has come to this conclusion, my lord. There's nothing, my lord. In fact, simply forensic report says that the signature does not match. Even I admit, my lord, signature doesn't match, but doesn't say, my lord, that the signature doesn't match means that the petitioner was the one who encouraged this. Where is the evidence to that effect? Kindly, my lord, may come. I'll just take your lordship to the statement under 161 of the informant, my lord, where he admits to whom. Yes, my lord. Yes, my lord. To whom he has submitted the application. Just one line I will read, my lord. At page 78. On submission at second paragraph, on 28/8/2017, I'll skip that part, just relevant part I will read. On submission of the application to the HDFC Bank in the letter pad of Anjana distributor by Lukuram Prajapat by forging the signature of Sim Gupta, received the application and on verification, forged my account, became Sangeeta Medi, an official of the bank, made my account non-operational. My entire this deposition under 161 doesn't reveal my name anywhere or how I'm linked in this particular case.
Come to page 83.
My lord. In 83, my lord, the deposition made by one of the employees, Bonali Goswami, she says that this application, yes, my lord, I'll read. My name and address, I'm serving in HDFC Banks in 2015.
Last 4 lines.
Yes, my lord. The 3 signatures appearing in application seek a signature, Sangeeta Medi signatures appearing AG, that is current petitioner, and signature of Ashwin Chakraborty, I do not know. Yes, my lord, we are not denying. The application that did came to my table, and as an employee of the bank, it is mandated that every application, after being scrutinized by the officials below her, she will have to give an approval. So this was placed before her. The only thing is how, by approving the application to lift this ban and to, my lord, connive with the main accused, they have not able to establish anything. Hundreds of applications, they fall, my lord, in bank. Man, it's humanly even not possible for a person standing, sitting as an operational manager to re-scrutinize each and every document which has already been done by the subordinate officers, my lord. My lord, now, may kindly come why I'm saying that the FIR was concocted, because, my lord, on that particular date when the money was taken, which he alleges at page 76, my lord, I have given the relevant transaction where this 4,80,000, according to him, was through a check. It was, my lord, went into the account of the main accused, but from the statements, it clearly indicates that, my lord, may kindly come to page 76. My lord, on 29/8/2017, if your lordship sees the second, my lord, second line, my lord, in fact, there is a mention, my lord, this transaction TPT Anjana. If you have my last form, then your lordship will see that there is a check reference. This is not check, this is online reference. I have confirmed, my lord. And 4,80,000 has been withdrawn. And now lordship will come below on 13/9/2017, the mentioning of 45 lakhs, which was bounced, is also reflected here. Now there is a check number reference made on 13/9/2017 of check dated 1/12 of 45 lakhs, which was bounced. So why did not this particular gentleman who filed the Azahar had to file an Azahar on 13/9, my lord? Why did he have to wait till November? My lord, nothing has been explained. his check was bounced in 2000, in September month. Had there been any, my lord, actual incident occurring of forging or, my lord, whatever he's claiming, then this gentleman should have gone there immediately. He has conveniently taken, my lord, 3-4 months, and now he has entangled all the bank officials. But this is purely a rivalry between the two businessmen, my lord. He, in order to cover this case under the NI Act, has hatched this particular story in the FIR. My lord, it will be a purely an abuse of the process of law, my lord, if this petitioner has been, my lord, made to appear before the learned trial court, my lord. This is my humble submission, my lord. Because remotely also she cannot be made or implicated in this matter, my lord. This is my humble submission.
Otherwise, my lord, in this case, my lord, petitioner has approached before this honorable court against the order of framing charge by the trial court, my lord. And the scope of interference in the order of framing charge is very limited, my lord. And I would like to point out, my lord, on page 74, your lordship, the order passed by the learned trial court. And in case of, my lord, order framing charge, it is not required by the trial court to look into the probative value of the materials available on record. If there is prima facie satisfaction, my lord, grave doubt that the petitioner is involved in commission of the offense, my lord, then my lord, trial court may, my lord, frame charge. Your lordship may come to, my lord, paragraph, fifth paragraph, my lord, it appears, my lord, last portion. It appears that the allegation brought by prosecution prima facie shows that there are indeed incriminating materials available against the accused persons being part of a conspiracy, which can only be executed on a trial. So, my lord, there is no, my lord, illegality in the order passed by the trial court, whether petitioner is involved in the conspiracy, but prima facie there are materials, my lord. Initially, my lord, that account is a, my lord, petitioner has filed application for that account is a, my lord, no debit account, and thereafter, my lord, he has filed application to call to, my lord, cancel all his signed and unsigned checks, and there are, my lord, other disputed facts, my lord. Thereafter, for a single time, my lord, that my lord, no debit account status was lifted by filing in her application, but by filing application by the complainant. These are all, my lord, issues, my lord, which can be executed only during trial, my lord. So, my lord, there is a trial court at this stage finding all these materials, my lord, rightly frame charge against the accused person, whether she is a part of the conspiracy or not, that can only be executed during trial, my lord. So at this stage, my lord, I do not find any illegality in the order passed by the trial court, my lord.
Or Mr. H. also representing for the petition. Prosecuted. Petitioner. While serving in the HDFC Bank of Nagar branch. Signed in an application. Which was found to be forged. That are being investigation. So the petitioner is not an affair named accused. Bhangar PS case number 247 of 2017. But on completion of the investigation, Proceed was filed against 5 of the accused persons, including 3 personnel of the SDFC Bank, Bhangar branch, including the petition in the search sheet dated 06/12/2018. In search sheet number 78 of the 2001. Submitted on 06/12. Okay. Mr. Puragan, do you have the GR case number with you?
Yes, my lord, it is PRC case number, rather, my lord, 1820.
That there will be GR case that has been registered as GR later on.
My lord, but in the order, it's only written as PRC
Can
case.
we also submission of the cert?
Anyway, even in the charge sheet also, I have cross-checked, my lord. But yeah, it's put on.
Profiling of the cert sheet. Inside Bhangar PS case number 247/2017. The same was registered as PRC number 1820/2018. And the learned the Judicial Magistrate First Class in bracket 3 Kamrup Metro Guwahati by its order dated 03/10/2024 rejected the application of the petitioner to discharge her from the said PRC number such and such and to cognizance of the offence under sections 120 within bracket P of the 420 of the 468 of the 471 IPC. Being agreed for the said rejection of the judge in said PRC number such and such. The petitioner filed this criminal petition or forcing of the proceeding against her. The petition contended that while signing the application allegedly submitted by the informant of the case, she was not aware that it was a forged document submitted by the one of the accused persons of the case. And as a bank employee, she had countersigned the said bank, said application by one of the accused petition. However, it also submitted on behalf of the petitioner that at that stage of signing of the application, countersigning of the application, by the petitioner. It was not possible on her part to determine whether the same was a posed one or not. Placing the order dated 03/10/2024, passed by the London Plain Officer, number 3, Kamrup Metro Party, in said PRC number such and such. Mr. Such and such, plan additional public prosecutor subject. That the learned magistrate prima facie being satisfied with the materials available on record, took cognizance of the offense under section 120B, 420, 468, 471 IPC against the petitioner and other accused persons of the case, and rejected it as application of petition. And therefore he submitted that it said order dated such and such 03/10/2024, passed in PRC number 1820291, doesn't call for any indictments. Issue notice returnable by 28th of June. As such and such and such, no formal appointment to make sure. Call for the eligible scan copy of the records of PRC number such and such, along with the records of honorable PS case number 247 of the 201. List according. The interim pair of the petitioner shall be considered on the perusal of the relevant records and the returnable date.
I pray for some protection today, my lord.
The returnable date.
Okay, I'm obliged.
May I please also? Here I'm maintenance proceeding, my lord. We are challenging the order passed by the additional session of Margarita Chinchike. Wherein, my lord, the SDGM, Margarita has awarded, my lord, compensation, my lord, the quantum of compensation and at the rate of 6,000 each, my lord, to the side of the petitioners. Thereafter, my lord, my lord, the opposite parties have filed a, my lord, appeal, and after, my lord, the last session that is reduced, my lord, it. So, my lord, raised 4,000, my lord. So, my lord, private parties, the lordship may, this is a notice may be issued, my lord. My lord will find the page 40, my lord. That is the relevant portions, that in the order passed by the session judge, reducing the, my lord, quantum of compensation to 4,000 from 6,000, my lord. Who has not, my lord, considered the evidence, the financial capacity of the petitioners. My lord, he got the opposite party is in, my lord, government service holder, my lord, railway employee. The evidence has not been considered in proper perspective, my lord. FPGM order, lordship will find page 34. Page 34, lordship, para 41. That is the order, my lord, observation direction issued by the FPGM.
Heard Mr. BK, counsel appearing for the petition.
And that's.
So an additional public prosecutor appearing for the state. In an application filed under section 125 CFC by the petitioner against the respondent number 3, being in this case number 08 of 2022, the learned judicial magistrate, subdivisional judicial magistrate, Margarita, by judgment dated 07/08/2023, directed the respondent number 2 to pay rupees 6,000 to the petitioner. Rupees 6,000 each to the petitioner and two of her daughters as maintenance. Against the same, the response number 2 preferred a revision petition. Being criminal revision number 02 in bracket 1 oblique 024. The Learned Additional Session Judge Margarita Tinsukia. The judgment dated 7/12/2024. First in set criminal revision number 02 in bracket 1 oblique 2024. Modify the said order of the learned. Them actually follow. Did it such and such. SDJ within the Margarita. There is 07/08/2023. Fasting. Next 08/2022. And directed the response number 2 to pay rupees 4,000 each to two of her minor daughters only with effect from date of filing of the maintenance application. I dated 02/02. Being agreed, the petitioner has filed this criminal petition. Issue notice returnable by 25th of June. As I must say, that's the election of the prosecutor has accepted notice on behalf of the responsible. So extra copy by whom along with the application. Petitioner self expects for services notice on the response number 2 by registered prosecutor by tomorrow for cutting as well. Call for the records of legible scan copy of the records of case number, miss case number 08/2022 from the Court of Learned Sub-Division Judicial Magistrate within bracket and Margarita, as well as the records of criminal division number such 02 in bracket 1/2024 from the Court of Learned Judicial Session Judge Margarita. So register judicial.
May I please your lordship? So this present petition is for quashing the proceeding of PRC case number 384/24 pending before the Learned Court of SDCM Guwahati. Here in this case, lordship, this instant case is arising out of a Bhagwan PS case number 21/24 under section 294, 506, 325 and 34. This instant FIR is the counter plus to the earlier FIR filed by the present petitioner's wife, lordship. They have filed this SIR after 19 days from the date of occurrence of the actual incident, lordship. And there is no prima facie any case material against this present petitioner, lordship. Allegations are totally concocted and frivolous, lordship. FIR lordship will find in page number 18, lordship, the vernacular, lordship. May I read it out, lordship?
Petitioners. And I must say that's an additional possibility appearing for your state respondent. In an affair, laws were the respondent number two. Before the officer in charge of one police station. Bhagwan PS case number 21/2024. Under section 294/506/325/34 of the IPC. Corresponding to GR number 320/2024 was registered. After completion of the investigation, subsequent said Bhagwan PS case number 21/2024 was submitted on 31/05/2024 by charge sheet number 21/2024 against the certain petitions. Thereafter, the said GR case number such and such registered as PRC number 384/2024. And the learned Chief Judicial Magistrate, Golpara, by order dated 07/06/2024, to cognizance of the offence under section 29(4)/06(3)-434 IPC against the petitioners in said PRC number 384/2024 arising out of on one PS case such and such corresponding to Jeremy. Agreed by the said, the petitioner has filed this criminal petition on 2005/2022. Contention of the petition is hearing at that earlier wife of the petition on 02/08/2028 filed an FIR against the present respondent number 2 and others before the Bhagwan police station, which was registered as Bhagwan police station case number 20/2004 under section 341 of the 325 of the 34 IPC corresponding to GR number 319 of the 34. It is placed by the petitioner that in said Bhagwan PS case number 20/2024 on the basis of the affair laws by wife of the petitioner number 1. Charge sheet was filed on 30/09/2024 by charge sheet number 42/2024. Against the respondent number 2 and others. Under sections 143/341/323/506. It is submitted by the petitioners that the entire proceeding of Bhagwan PS case number 21/2024 laws on the basis of the affair, it is 02/04/2024 laws by the respondent number 2 Then the counter blocks to the FIR laws by the petitioner number one, wife of the petition number one on 02042024. On 02042024. Thing. One PS case number 20/2024. Corresponding to GR number 319 of it. This is notice returnable by 24th of June. And such no formal notice. Extra copies that tomorrow prior to it. Petitioners shall take state for service of this on the response number 2 by registered for security. That tomorrow providing is correct and to protect the steps. Call for the records of PRC number 384 of the 2024. Along with the records of the one PS case number 21 of the 2024. From the Court of Lanat South Regional Judicial Magistrate within the that's much other ballpark. The interim pay of the petitioner shall be considered on the returnable debt on perusal of the 11 records that has.
And this petition has been filed by under section 528 of Bharatiya Noise Suraksha Samhita, my lord, for quashing the proceeding of CR case number 596 of 24, my lord, under sections, my lord, 356(2), 351(2) and 3162, my lord. As there is no case made out in the complaint, my lord, you also will find the complaint at page 11, my lord. This allegation is that, my lord, the complainant has 2 children, my lord. Daughter is 23 years and son is 19 years, my lord. And allegation is that, my lord, we are the, my lord, own Moha and Mahi of the children, my lord. Petitioner number 2 and the complainant are own sisters, my lord. We instigate her children, my lord. That allegation is that we instigate the children to misbehave with her, my lord. That is the main allegation, my lord. And the learned court below, my lord, without recording the statement of the informant, complainant, my lord, notice has been issued to us, my lord. So you will find the complaint at page 11, my lord. That we all along instigate them, my lord. They come to our house. So we are own Moha and Mahi, my lord. This is a story of 3 sisters, my lord. In fact, my lord, one sister is already died, my lord. Original accused number 1, she has died, my lord. Absolutely no case, absurd things are stated here, my lord. It's a totally unbelievable, my lord.
Pardon, Mr. as Mr. Counsel appearing for the petition. Petitioners. And the sole respondent, sole opposite party. On 06092024. File a complaint case against the petition for the Court of Lanat Chief Judicial Minister from platform. It was registered as complaint case number 596. For civility complaint. Public 024. In the said complaint, the sole respondent prayed before the Lanat Court to take cognizance of the offences under sections 356 within bracket 2, oblique 351 within bracket 2, oblique 3, oblique 316 within bracket 2 of the PNS 2003 against the petitioners. The learned State Judicial Magistrate come with me. As per the state complaint case, being CR number 596C, 2024. To the Court of Learned Judicial Magistrate First Class Cambridge High Court. For disposal. We are recording the statement of the complainant and our witness. Witness recruit in the cadet. The learned Judicial Magistrate First Class Cambridge Metro County by order dated 25/09/2024. Issued notice to the petitioners plus alleged accused persons. Also, Mr. Mukta Lanet, counsel appearing for this petition, that the said order, the Lanet Magistrate JMF Select. Dated 25/09/2024. In said here, number 596C on the 2024. Being not in conformity, raised for passing of the said proceeding of such adjustments against the petition. Issue notice returnable by twenty-fifth of June. Petitioners are directed to take steps to serve such notice and the sole respondent by registered person that will not provide. Call for the records of complaint case 596, records of 596C, 2024. From the Court of Learned Judicial Magistrate First Class Cambridge Metro. Till the returnable date. That is such. The proceeding of said CR number 596C, public 2024. Pending before the Court of Learned Judicial Cambridge Metro County against the petitioners. Self-ending.
Keep your line.
It's subject to taking steps.
Yeah, Lordship. Lordship, application for questioning of the NBW order dated Lordship 9/5/2025 Lordship. Lordship, order is in page number 22 Lordship.
Do one thing. Remove this day after tomorrow and let us know the date when is the next date.
Look, next Lordship 26 Lordship 26.
26th of June.
Yes, Lordship.
26th of May.
26 June Lordship. The next day 26 June Lordship.
Okay, you appear before the Learned Judicial Magistrate First Class Cambridge Metro Guwahati on or before 13th of June. We pass that. This one. Yes, we appear on or before 13th.
Publish Lordship.
May please, Lordship. Immediately petition for quashing of NBW issued by the CDM in Sukia, 125/4/2025. The next date is fixed on 21/6/25.
21/5/25.
21/5, what is the next date?
Next 21/6.
We are also appear. Lot. For the State Judicial Magistrate in Sukia on or before 13th along with the certified copy. All right.
My lord, diary will be required now.
On 10th of June, Lordship. It's not perfect, yes. On 6th of June, Lordship.
6th of June.
Lordship.
Just put this case number 63 of it.
Can you be little bit travel in?
Today is 26th.
26.
From Tejpur, Lordship.
Can it be on 5th?
4th or 5th, 4th or 5th. Right?
Fine, I'm always.
Make the your lordship. There is a 3 years bail application, your lordship. Page 9 is the FIR. The petitioner, my lord, is the owner of a petrol pump and tanker was parked, my lord. Dada, DD was. You're not part of it. DD was in. You're all part of it. If you arrest the accused, management. Lordship, may I place one order, my lord, with lordship permission? Dada, DD was. Here, my lord, there was no theft of any oil, my lord, nothing, my lord. Paragraph 4, page 4, my lord, of that order, my lord. Everything was intact, my lord. It is clearly reflected in the order, my lord. On page 4, my lord, the second paragraph. While granting bail to the other, of course, one of those persons are arrested, my lord. There was, everything was intact. No, only the vehicle was parked, my lord, at the backside of the, my lord, petitioner's, my lord, petrol pump. But there was.
Consider on the fourth, first or fourth, to consider on that.
Lordship, till then, my lord,
Not at this stage. Let us see, to consider. On fourth.
but there was no, everything was intact. Not even a drop of money, everything was inside, my lord. Paragraph 4, page 4, my lord, it is clearly reflected from the order, my lord. Of course, those persons were arrested, my lord, but that is what you say. It was passed, my lord, on perusal of the case diary. It is seen, my lord, from experts, my lord, that again, no oil was stolen, my lord. It was found to be okay. It did not drive an engine.
Okay. Appear before the IO. Get the case diary by Kent. Appear before the IO on 29th. Right.
I'm deeply obliged, your lord.
Mr. Saxon, sir, and consider appearing for the petition. I have also placed a copy of the order ticket 16052025, part well and the MFCC. Let's put. Relating to Saridor PS case number 61, depleting of 25. In which two of the accused persons arrested in the new on perusal of the case there. Okay.
It's a 482 application, not GNS. In connection with CIDPS case number 21/2019, my lord.
Get the case there.
Fourth lordship.
My lord, my name is nowhere sold.
Let us see the case there.
My lord, my age was, my lord, 17 years at the relevant time.
We'll consider and we'll see.
Fourth, sixth lordship.
Okay.
My interview may be considered, my lord.
The institutes. Yes, sir.
Attempt 32, lordship, we have filed additional affidavit that is not on record. So may I pray that matter will be fixed on Thursday along with that affidavit, lordship? We have filed on 20/05/2020.
বাকি হচ্ছে এই অটিটা লেখা লাগবে।
My lord. 53, my lord, and senior friend is appearing now. $52, my lord, I am just praying for the recall of the NBW, my lord, so that I can appear before the tribunal, my lord, court below. Because there is no other, my lord, prayer. And in 53, my lord, senior friend is appearing, my lord. That is a different case, my lord. They are praying for the quashing of the entire proceeding, my lord. In fact, the petitioner is a victim in this case, my lord. She filed a criminal case against the brother of the, my lord, informant of the present case. And against that, the brother has filed the present case. In that case, charge sheet has been filed under 376, my lord. And now as the brother cannot file case, my lord, another brother came before this, the tribunal, my lord, trial court, and they filed the complaint case, my lord. Those are matter of, my lord, argument, and in fact, those are matter of evidence, my lord. Whatever their evidence, that will go. Filing complaint against the victim person, my lord. In fact, the police has filed FR. That has been, my lord, thereafter, probably after filing of that, my lord, the Naraji petition, that has been converted to CR. Now only my prayer was indeed, my lord, in the present 52, that I could not appear due to medical emergency, my lord. So in fact, we filed a petition before the court below also. That has been rejected, my lord. So my humble prayer is that I will appear, and I may be.
On which date you will appear?
Any date, as your lordship.
Just tell us on which date. You tell us the fine.
The next week itself, my lord. If your lordship ready, any date.
You tell us, will according to Pakistan.
Tomorrow, day after tomorrow. Any date.
Appear on fourth.
Fourth, my lord. Yes, what happened? What is the problem, my lord? She's a school teacher in Arunachal. She'll have to join in first. So she'll have to come back again. Either before first or, my lord, she's here. Either before 4, my lord, so that she can, either before 1, so that she can appear and go back. She's now here in Guwahati.
38.
30th, on 30th. Okay. LBW record, my lord.
Do it first. Necessary order.
Yes.
Who is appearing in the second case? Mr.
My lord.
I have not taken step here.
Steps you have taken.
When?
Twice.
Taken.
They have taken steps.
That's the report.
Office not giving them.
That's why I'm saying.
My lord, the other day, document था. नहीं दिया जाके. We'll verify that, my lord. But I know he went to the clerk. He told me that much I know. Then therefore I don't know, my lord. क्या हुआ? आपको बेटे को क्या है? कोई ऐसे ऐसा क्या है? You should read with you. अष्टमी वैसा किया. अरे भाई क्या है? कुछ में क्या है? देखो ना स्टेप लिया है आपने.
251202.
ऐसा क्यों करते हैं? कौन सा काम किया आपने? वो स्टेप जो लिया क्लार्क का पेपर का है. देखिए, again very inactive. Kuchona, please go outside and ask him. Go. Kasare.
Voter question 9-4 होने के तो 9-4-25.
Step
हाँ, postal talabana. Postal talabana 9-4-25.
9-4-25, which shows my lord postal Talabana have taken.
How much? Talabana.
9-4.
Postal talabana money of rupees 3 rupees for registered post. It is here for us. That is the reason you are asking.
That's why I'm telling him he is the one I have. In fact, I was.
This is what is really.
I was disappointed with him, my lord. In fact,
the order is supposed to be by registered post.
I was disappointed with him. Just now, I said, go and ask your client what he has done, my lord.
Postal talabana is of rupees 3.
How can it go by register post, my lord?
60.
It's common sense, my lord. It cannot go.
That's what.
I'm surprised also. I repeatedly told him, go and check it out.
It was taken on 9th of April.
Can you, my lord, give me one date? Let me.
That
There's
is
no.
only of rupees 360.
How can it, my lord? How can it go?
You know.
No, actually, what
Take
happens,
care.
my lord? I understood.
It is, that's what it is before us. On
Yes.
9th April, the step
Yes.
was taken only of rupees 3.60.
What I understood, my lord, not regular. Lord, you understood, no?
Take it, okay.
Yes,
Take
yes,
it,
yes,
take it,
yes,
take it
yes,
immediately.
yes. Give me one more date, my lord. I'll just. Otherwise, they'll make me, in this case, what I'll do, totally on the law point. I'll just make submissions.
Take steps first.
Yes,
That is the
yes.
reason the opposite party is not yet aware.
Register for 3 rupees liya hai.
The priority council for the petitioner. We're not writing about you. The priority council for the petitioner. He is allowed to take steps by registered post
3 rupees liya hai.
on the rest number.
किसको दिया था क्लाइंट क्लार्क को? आपको तो प्यारा है ना.
By tomorrow, forwarding is correct. Person to open 0505. Okay.
Lordship is given any date, my lord?
By tomorrow. Take steps
By tomorrow. Yes, yes, yes. Okay.
There is after 4 weeks.
May I please you, lordship? Lordship, but lordship, I am the accused number 3, lordship. Lordship may kind to see the affair, lordship. Like so far, allegation against me, lordship, I have instigated the accused number 1 to give promise for marriage, proposal for marriage, lordship. Is 11 onwards, lordship, affair, lordship. The main accused has already been arrested, lordship. Accused number 1 arrested on 11/5/24.
Mr. J. Abbas, right?
Abbas.
Council appearing for the petition. And I must say that's an additional of the prosecutor appearing for the state. Petition and such and such and such. Apprehending the explain. The petitioner in English such and such. Let's file this application and this second 482 BNSS on 23052025. Praying for this prayers will interrogate PH case number such and such under such and such and such. BNS section 6 of the PSU were corresponding to GR number 581 public 2005. Is submitted by the petition that the main accused of the case has already been arrested and he is moving connected. Procedural Islam already been arrested. And protected for the next petition arrested with the marks on 11 to Section 4. Yeah. The case in hand. Petitioner let's wait for his bail. Petitioner is an apparent name accused in state Jaguar PS case number such and such under such and such and such. Considering the provisions of section 482 in bracket 4 of the BNSS. This PS bail application of the petition Jaguar PS case number such and such under section such and such. Being not maintainable. Stand. Yes, next. Representation on behalf of the petitioner. On call.
Number 10, your lordship, regarding the my report. My lord, regarding the my city case.
Fixed by the register. After a week.
Here in this case, Lordship, we have filed one additional affidavit on 20/05/2025, Lordship. So that is not on record. So may I please, along with that affidavit, a date will be fixed.
Mr. Riyaz, council appearing for the petition is submitted. In that way. An additional affidavit has been filed in this session. Which is not available with the case to file. List on 38th of June.
Can it be accept 30 Lordship or 29 or Monday Lordship any day?
29, you can have it on second, no problem, but 29 you have many cases.
Lordship, on second Lordship.
Second?
30 I have some difficulty.
Oh, on 22nd.
Lordship, how like this?
Wait, please, Your Lordship. What's a regular bail matter where charge sheet has been laid matter? The Lordship will have a look at page 17 for a once matter, 17 matter.
Scan copy, my lord, not yet received, man.
Not yet received.
Not yet received.
Was called for.
Yes, man. Officially.
It has to come from which group?
No, my lord, may I submit, my lord? The record was here, my lord. That's why I'm pointing out to page 17, my lord, 17 for a once matter. Page 17.
Was from cause list, my lord, not
Not
reflect.
yeah.
Yes, Mr. Dr.
যদি আহে লাগে। Page 17, my lord. My lordship is seen where, my lord, serial number 1, my lord, Motibur Bhuya, my lord. He is the present petitioner, my lord, in the instant claim. Now, lordship, may turn to next page, my lord, page 18, my lord, 18, my lord. Here, my lord, that 4, 5 and 7, my lord, and 6, my lord, they have been granted bail by this court, my lord. Yes, my lord. Can I place the order, my lord? Well, I have marked 1, my lord, in the top, my lord. My lord, so far, my lord, Abat and Abdul Wadot, my lord.
Just a minute.
Otherwise, my lord, I have not gone through the LCR, man, because.
So in the order, so there is a mention that the record has been called for.
In motion stage, I was not there, my lord.
No, I am not.
The record may be in, my lord, BA 1606, my lord, because it was disposed of on, my lord, 2205, my lord, last week only, my lord. On Thursday, last Thursday, my lord.
Okay, we can do one thing.
Man,
List on 28,
20.
along the records of bail application number 1606/2025. Disposed of on 22/05/2025 as well as bail application number 1258/2025. Disposed of on 20/05/2025. Okay.
Man, that to order may be kept on record. I'm on.
Right. Wait, please, your lordship. Am I the name that
Khairul Islam. It's not present.
Here, my lord, the petitioner is behind the bars for 9 months, your lordship. It's a POXO matter.
Emeritus is not right.
But name is shown, lordship.
Name shown, Khairul Islam.
America's not second. You have to consider when.
No, there is a second.
APR versus second. What is the declaration? Okay, page 48 is the notice under section 47 BNSL.
Yes. Doesn't appear.
Not yet.
The name has been shown, my lord, 1K Islam. But here I'm taking the plea, my lord, page 48, my lord. There's no grounds of arrest or regions of arrest have been, my lord, mentioned in the notice which was served upon me under section 47 of the Civil.
Do one thing. Mr. Rasamanpullah, counsel appearing for the petition. And MS Kojas, two public prosecutor. Though, the counsel for the number
Case number
that's
two.
number 2
Finally.
slash informant of the case from father of the minority came up with the audit. But during the deliberation, the respondent to informant remain on present. MS Manisha Karan. Right. List on second. List is Chalo. We'll have it on second.
Lots of, deeply obliging.
May I please? ইনফরমেশন পালে নাকি বা ইনফরমেশন পালে সার্ভিস হয়েছে এটা পুলিশের টুকু লঙ্কা প্লেট
Mr. Sharma. My lord. You have the information if the notice has been served on the. No, my lord. Why? We have asked Mr. Parashar in last day. Yes, my lord.
Qualification there for tomorrow.
List on court. Enabling the officer in charge of Longa Police Station to apprise the court about the service of notice of this bail application on the opposite party number 2.
4th of June. What of June is it?
Oh.
What of difficult either?
Of the case. And mother of the victim.
My lord.
Order to Mr. Bankim Sharma, additional public prosecutor for the.
My lord, I have some difficulties on 4th of June, my lord. But can they be fixed after 6th, my lord?
That's 60.
My lord.
9th?
My lord.
9th.
Highly obliged.
Yes, Bongaigaon GRPS case, Mr. Kotaku.
Yes, my lord. Case diary received, my lord.
Tell us.
My lord. FIR is my lord, page 12. my lord. Operative party at my lord. 16.
अपना तो 7.79 kg में है kg में सर
59.
उसको तुम नहीं बेसी होने सबको उसमें
70 days of it. 69 days.
69
आज ही लो.
फिर किमान दिन में होता है करने 60 days
Confirm now, then. Finish. Monthly. 32 weekly. $7.79 kilograms of.
My lord, already today is 69 days, already mandatory period is final thing already.
One in the code, 60 days and 90 days. Yes, yes.
We have the FSL report.
No, the FSL report not yet.
Last order, madam. But can you check with it? And apart from that, madam, so far the comprehensive section 47 and 48, BNSS sector, madam, that is not madam carried out by the authority, madam. Yeah.
Yes, percentage.
Yes, Mr. Sharma, what do you have to say?
My lord, while my lord, I was traveling by the train, my lord, and my lord, approaching my lord, towards my home. One bag was kept in the my lord, bank of my lord, which was not mine, my lord. While I entered the my lord, platform, my lord, I my lord, along with my own bag, my lord. That was also in the my lord, CCTV footage, my lord, in the platform, my lord. But while the my lord, police is there, my lord, the black color that I have mentioned in paragraph 6, my lord, of my petition, my lord. That was not belong to me. What I have, my lord, only my lord, inside the bag of the idea was a packet of 3 leaves of 1 kg, one day along with some apparels, my lord. That was belong to me, my lord. But that which was my lord, contained with ganja, but that was not belong to me. And it is also in the my lord, entire platform was under surveillance of the CCTV, my lord. That can be also my lord, the charge, just from my lord. Apparently, my lord, another ground, while the notice was, my lord, given under section 47, my lord. Already I have been arrested, my lord. Annex 3, page 20, my lord. So compliance of section 47 and 48 is not seen there, my lord.
Why?
My lord, while I have already been arrested, my lord, that has to be my lord, served upon me prior to my arrest, my lord. Already I have been arrested. I was going to produce sections notice under section 47 and issued. Thereafter, my lord, I was allowed to call with my family members, those to make communication happen. Details of my lord, ground of arrest. What is in the affair, my lord, that is also only reflected, my lord. Lordship may take note of page 21, annex 4, my lord.
Hard Mr. Emerson, Council appearing to the public. And Mr. People of the arrangement of the public to the repairing first. Petitioner namely such and such. Well, this application under section 483 NHS 09042025. Praying for his way in providing of the RPS case number such and such. In the section such a function of the NDPS. Corresponding to the year number 141 2035. In which was taken into custody on 17/05/2025. Who the arrested and it was custody since then. Matter relates to recovery of 7.79 kg of suspected cannabis on the conscious position of the petition. A blue color airbag with inscription. No, blue color carrying the blue color airbag. While he was prevailing in 15909 Lalgarh Junction over the Assam Express. Within the capital, delivered as Lalgarh down. While it approached the new Bongaigaon railway station. So, the contention of the petitioner is that considering his detention in custody since 17/3/2025, he should be considered for the further. It is contended by the petition. It is alternative. So it is also considered by the petition that the bag from which the airbag from which the NDPS item was recovered doesn't belong to him, and it will be someone else. The petition further contended that at the time of his arrest, though notice under section 47 BNSS was issued to him on 17/03/2025, but the same is not in conformity with the provisions of section 47 BNSS. As well as the law later on by the Honorable Apex Court in the case of the broadcast. There is the case that he placed before the court by Mr. Pro. Court of Variation Public Proceeding. It is seen that on the basis of specific information, police personnel from Bongaigaon GLP, New Bongaigaon GLP, apprehend the petition from Lalgarh down number 159093 at New Bongaigaon railway station. And from his conscious position, 7.7 kgs of cannabis in the Ganja were recovered on 17/03/2025. We'll see that the process of recovery by the Bongaigaon JLPS was done presence of independent witnesses. From the records of the case, it is seen that while arresting the petitioner on 17/03/2025, his cousin brother Sushil Rajvanshi was able to sign and the arrest memo as a signal, the witness to the arrest of the petition. From the records of the case as well as the annexure 4 to this petition, it is seen that section 47 BNSS notice was issued to the petitioner by the investigating officer, State Bongaigaon DPS 9 kilo. Right. In the notice, Mr. Sharma, Additional Planning Council, according to the petition was submitted, that he was served with notice only after his arrest. On being inquired, Mr. Sharma submitted that letter itself, that said notice under section 47 BNS itself
specified that he has been already arrested. From the said notice under section 47B annexed to this petition, as well as from the record, it is seen that the petitioner was informed that he has been arrested in reference to Bongaigaon GRPS case number 26/2025 under section 20 in bracket small b in bracket small Roman 2 in bracket capital B public 29 of the NDPS Act. And he's been referred to the Chief Judicial Magistrate Bongaigaon as he has been taken into custody because of non-bailable, because of the offenses are non-bailable by police. And he may submit petition before the Honorable Court for date. In the suit notice under section 47B under the reference, Bongaigaon GRPS case number 26/2025 under section 20 in bracket small b in bracket small Roman 2 in bracket capital B public 29 NDPS Act. Was referred and the petitioner accordingly received the same notice under section 3 of 47B NHS. Before he was produced reported on it. Chief Judicial Magistrate at Mobile. From the perusal of the said notice of the section 47B NHS, it can be seen that the concerned investigating officer of the case have given him details of the sections under which he has been arrested and also inform him that bail cannot be given to him by police. As such, he was advised to submission to petition before the Honorable Court for hearing. Further, from the arrest warrant annexed to this petition as well as from the records of the case, it is seen that one Susil Rajwangshi, whom the petitioner was present at the time of the arrest of the petition. Considering such materials, the recovery of 7.79 kgs of cannabis from the conscious possession of the petition. The court found that the right, the information to be furnished to the petitioner at the time of his arrest pertaining to the sanction, particularly to the sanction of the which he has been arrested, has not been violated. Moreover, the petitioner has also been informed that as he has been arrested on non-bailable sections, he may approach the court for his bail. The recovery of 7.79 kgs of suspected cannabis. It is seen that the FSL report is yet to be received by the concerned investigating officer. Recovery of 7.79 kgs of cannabis. It's a commercial purpose. As such, considering his detention in custody since 17/03/2025, consider states. That's reject. Return the case to.
May I submit one part? So far, Sushil Rajwangshi is concerned, he is not a cousin brother.
In the presence of witness,
He may, but he is not a cousin brother.
Second part is 7.79 kilo is not a commercial quantity. It is intermediate quantity. Commercial quantity is 10 kilograms.
Just a minute. Cannabis, right?
Yes, intermediate.
Intermediate.
Intermediate. Serial number 23,
My lord.
100 gram is the
Cannabis ganja, my lord. Cannabis is 100 grams. This cannabis ganja, my lord. Not the entire. Ganja, my lord.
yes. Ganja is yes.
Ganja. Ganja is not specifically mentioned. At my lord 55, man, serial number.
Less than commercial.
20 kilo, my lord, is the commercial quantity.
Less than. In that case, only for 60 days, I think.
Yes, my lord. I even asked him to point out that therefore, my lord,
written
I
all this?
submitted the 69 days already completed.
Because the default bill, why
My
are
lord.
you replacing all this?
Initially, my lord, I pointed out, I also asked him to submit.
Oh, pata. 7.79 billion.
No,
Modern 60 days in custody. No such default bill. 50,000. Two local series.
All right, unit.
May I please, lordship?
Please tell us, does it file or not?
No, my lord. This case charge sheet not filed.
Arrested on
28/3/2025.
what is the quantity?
Quantity, my lord, 39 grams of heroin and my lord, and without soap paste 10 grams.
Or what?
Intermediate quantity, my lord.
Special report is there? Not there.
No, my lord.
You are Mr. Council appealing for the petition. And Mr. Water. Petitioner named Arthur. Maintain the report to the defect paying for the plate. Jaguar Police Station, case number such and such on the sequence of the NDPS Act. Corresponding to GR number 406 of the 2025. Matter relates to recovery of 10 grams of suspected heroin from the conscious possession of the petitioner. Being inferred, Mr. Waterpool and additional prosecutors submitted that as on date, the FSL report has not been received, nor discharge has been filed. It's today is the 60th day of the detention to petitioner. Considering the same default with 50,000 to local saving.
God bless.
What the Yes, Mr. Chaudhary.
May I please your lordship? My lord, arrested on 9/4/2025. Intermediate quantity, little above than my lord, a small quantity. 8.41 grams of my lord heroin. Here, my lord, I am on two counts, my lord, that 47 and 48 notice. I have an X, my lord. As for my lord, 47. Annex. Annex, sir. NDPS, my lord,
Accurate case that you have?
Yes, ma'am, please.
Good.
3 persons have been arrested in connection with this case, my lord. This, my lord, she is a lady, my lord. Her son was also arrested, my lord. She was arrested at the night time. Daytime, my lord, police came to our house, my lord, and picked up this lady. And my lord, lordship will kindly look at, my lord, the notice under section 47, my lord. Annexation number 3, my lord. As per the, my lord, 47, person arrested to be informed of grounds of arrest and right to bail. Every police officer or other police arresting any person without warrant shall forthwith communicate to him full particulars of the offense for which he is arrested or other grounds of such arrest. But in our case, my lord, 47 and 48, my lord, just it's a duplicate, my lord. Lordship, it kindly come to, my lord, page, my lord, 21. And he is an illiterate lady, my lord. She has somehow put her signature in vernacular, my lord, Assamese. And this is all written in English, my lord. And as per my lord Vihan's Kumar's judgment, there is a reference of my lord Lalu Bhai, Jogi Bhai Patel, my lord, where it is stated, my lord, that this should be, my lord, language in the language, my lord, which one is, my lord, Detinu knows, my lord. Here, my lord, nothing has been, my lord, stated from whom, my lord, this heroin have been received, my lord, from the grounds of arrest. Nothing has been stated, my lord. From whom it has recovered, my lord, where from it has recovered. What has been recovered, nothing is there. And if we at page 21, lordship will find them, my lord, grounds of arrest. Come on.
What is the illegality?
My lord.
You are showing only the signature part.
Yes, one signature of the arrested accused, my lord, Mohini Das. She's an illiterate lady, my lord. She even didn't go to the primary school also, my lord. And my lord, her son, my lord, he has also been arrested. He is Maina Das. He was arrested at the night time.
Come to page number 18.
My lord.
Serial number 6 down below.
My lord. Page number 18, my lord. Serial number 6, my lord. In light of these factors, the accused custodian.
Paragraph C, page number 18. Bail objection, serial number 6. Of your
My lord. The accused woman, namely Mohini Das, is a habitual offender. That, my lord, police writes in each and every case, my lord.
Please
Whether, my lord, there is any this thing there, my lord.
Please
That she was
proceed.
arrested in the year 2023
Please proceed.
in connection with Jorhat Police Station, case number so and so. And the case was surseated by number so and so. Only thing, my lord, in this case, whether 4748 has been, my lord, followed or not, my lord.
One is complete, she has been informed.
My lord.
One is complete that she has been informed.
Information, my lord, as per Vihans Kumar's judgment, my lord. Only information will not do, my lord. What you will kindly look at, my lord, para 13, para 21, my lord. Vihan Kumar. In the light of Lalu Bhai Jogi Bhai Patel versus Union of India, in paragraph 20, this court held as it is an admitted position that the detainee does not know English. The grounds of detentions which were served on the detainee have been drawn up in English. It is true that Sri C.L. Antali, police inspector, who served the grounds of detention of the detainee, has filed an affidavit stating that he had fully explained the grounds of detention in Gujarati to the detainee. But that is not a sufficient compliance with the mandate of section Article 22, 5 of the Constitution, which requires that the grounds of detention must be communicated to the detainee. Communicate is a strong word. It means that sufficient knowledge of the basic facts constituting the grounds should be imparted effectively and fully to the detainee in writing in a language in which he understands. In our case, my lord, that is missing. If your lordship goes to my lord, notice.
But the act, the BNS doesn't say so.
My lord.
BNS doesn't say so.
BNS is also, my lord, it speaks so, my
Doesn't say
lord.
anything like that.
No, full particulars.
My lord, may I just read it, my lord? 47 lordship will kindly look into it, my lord. Full particulars of the offense.
See, in these days, we are going to that objection regions, section 50, as well as 58. There, it is very clear, if you go to the objection regions of section 50 and 50A of this chapter. Because there it is very clearly mentioned that only for the purpose that a person should be informed when without any warrant a person has been arrested, he should or she should be, arrestee should be informed the grounds
why he has been arrested. And informing him there are two parts. That since they've been arrested and he can approach the appropriate court for his bail. So considering that aspect, now in the BNS, there is nothing that it has to be communicated in the language. It may possible a person who doesn't know, but full particulars. He will be aware only of South Indian language. How do you expect somebody in Assam to write in something in Malayali or in Telugu or in Kannada language or in Tamil language? Is it possible? It's not possible.
But only thing, my lord, as it is
That
written
is why.
in English, my lord. So
It
as,
may possible, a person may write in Hindi, the signature may put in Hindi. Only thing is that he should be explained.
but only thing, my lord, lordship will kindly look at the, my lord, the order of the, my lord, learned session judge, my lord. Session judge has written that, my lord, that it is the duty of the police officer, my lord. Lordship will kindly look at page 25, my lord. Second paragraph. Upon perusing the arrest documents, I find that the detailed grounds of arrest have been mentioned, though the same are stated in English. Needless to say that it is the duty of the arresting police officer to explain the contents of the grounds of arrest to the accused in a language they understand.
No, that's a reason why, see, basically, in Viyansuma, the honorable, the lordships have said that it is the duty of the concerned magistrate to inquire whether he has been informed or not about the grounds of his arrest. And that is why the thing is there, but thing is, if it is a fact, the basically what we have to see is that there is no violation of Article 22.
My lord, that is the basic, my lord.
A person is informed of his arrest. Can you try to find out all these loopholes?
But what has been informed, my lord? That it has been, my lord, found in your house or from your position. Nothing is there, my.
Is it required?
Yes, my lord.
Where is that explanation?
Because, my lord, the full particulars of the, my lord, offense has to be stated.
Full particular, the offenses, the relevant sections will do.
That is 47, my lord. Full particulars has to be that what has been found in your possession, where it has been found. Nothing has been mentioned, my lord. And lordship will again look at the, my lord, the other, my lord, notice under section 48. There also, my lord, the ditto of this, my lord, the what has been, my lord, given to the, my lord, the detainee, my lord, to the arrested person. 48, my lord, the relative has to inform that your so and so has been, my lord, arrested for, my lord, position of this. If your lordship goes, my lord, 47, 48, it is ditto, my lord.
It is informed to some Nisha Bora. She
Yes.
also received it.
Lordship will kindly look 47, 48, my lord, not a, my lord, word, either and either, my lord.
What I have done on that day.
But here nothing has been mentioned, my lord, what I have done on that day, my lord. If anything has been found from my possession, my lord, that is also not there.
What I have done on.
Considering the, my lord, period of detention being a lady, and, my lord, it is little above the, my lord, small quantity, only 8, my lord. 8 milligrams. I pray, my lord, this lady may be released on bail, my lord. Nowhere, my lord, it is mentioned from where from or from my position, my lord. this heroin has been, my lord, recovered. And on that particular date, my lord, what I have done, it is written that I have projected myself as a peddler. That is not the case of, my lord, the affair or, my lord.
Then how police will investigate?
My
If
lord.
if a person is found with a possession of any NDPS item, and if it is found that somebody is a peddler, from which you have purchased one of the accused, then in that case, nobody will be arrested at all.
But that is missing in the, my lord, that notice under section
So that is why
47.
I'm saying the accused person just read three. Page number 21.
21, page 21, paragraph number 3. Point number.
The accused person promotes practice of selling illicit narcotic drugs in Jorhat town area.
Then
Accused Dibbojyoti Das takes illicit drugs from her and her son Jayanto Das Moina Das with a promise that he would expand their business and would help in collection of handsome return.
it's basically network.
But, my lord, on that particular date, my lord, what this, my lord, lady has done, and whether from her possession, my lord, these heroines have been recovered.
Otherwise, yes, my lord, it is a fact that, my lord, grounds of arrest were, my lord, communicated to the accused person, my lord. There is no doubt about that, my lord. And grounds of arrest were in English, but your lordship, as my lord, your lordship may kindly peruse, my lord, the order of the learned trial court was pointed out. From the same order, I would also like to, my lord, point out to your lordship that at the point of time, at the point when bail application was filed, it is not the argument of the accused person that I have not understood the contents of the, my lord, grounds of arrest. So only because, my lord, the learned trial judge himself has, my lord, write that, my lord, sentence by stating, by, my lord, pointing out to the police officer that it is your duty to, my lord, inform the accused about the grounds in the vernacular language, my lord. But however, it is not the point of the accused person before, while filing the bail application, that because of the contents of my lord, grounds of arrest in English. So, my lord, it is not possible for me to understand the contents of the same.
That is written, my lord,
It
in
is
the
not
bail
the
application,
argument
my
of the
lord.
petitioner.
That will be in the bail application, not in the order sheet.
However, that bail application that was pointed out by my lord, learned friend, that's why I am pointing out to your lordship.
Because, my lord, court has, my lord, presumed, my lord, that it was the duty of the police officer. Police officer has explained that, my lord. Needless to say, that is the duty of the arresting police officer to explain the contents of the grounds of arrest.
Otherwise, my
But
lord,
whether, my lord, that has been, my lord, ascertained from the police officer by the, my lord, learned special judge.
otherwise, my lord, it is the, my lord, mandate of the as per the to comply the Bihan Kumar's judgment, my lord. Yes, now it is required to, my lord, provide the grounds of arrest in writing to the accused person. Those grounds of arrest provided, and whether those grounds of arrest were sufficient or not sufficient, and, my lord, how much amount of, my lord, investigation of the investigation police, my lord, had to reveal to the accused, my lord, there is no such guideline application, and, my lord, there is no such, my lord, guidelines for Sasmal till now, my lord. There is no such guideline issued, my lord. And, my lord, how can every information of the investigation, my lord, police can write in the grounds of arrest, my lord? And from the grounds of arrest, it is seen that, my lord, there are 12, my lord, 5 grounds of arrest wherein, my lord, specifically mentioned one depository dust was arrested on the basis of information. Thereafter, my lord, house of the present accused person was searched, and thereafter from the house of the present petitioner, those, my lord, contrabands were recovered, my lord. And the present accused person also earlier involved in one another NDPS same offense, my lord. In that case, my lord, search sheet also submitted, my lord.
Whole 50
Otherwise,
section
my lord, there
also,
is sufficient compliance of, my lord, Bihan Kumar in this case. My lord.
Yes, Mr. Chaudhary.
My lord, a very basic thing is missing in this, my lord, 48 notice, my lord. 50 of the, my lord, old CRPC, my lord.
Now, 48 is next page.
Yes.
Is,
This case is for 48, my lord.
next page.
This case belongs to 48, my lord, BNSS.
That's why, and it's a 4.
Yes. 50 also, my lord, it is stated that every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offense, my lord. Where is the full particulars of the offense in, my lord, the present, my lord, 48 notice?
Good relation with some other. That thing that I have done.
If your lordship goes through, my lord, the 48 notice, my lord, nowhere, my lord, full particulars of the offense has not been explained. This is regarding, my lord, the investigation part they have, my lord, given in the 48 notice, my lord. The investigation so far progress, very day of arrest, my lord.
Read 48, PNF.
Yes. Every police sorry. DNS to there. Every police officer or other person making any arrest under this Sanhita shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his relatives, friends, or such other persons as may be disclosed or nominated by the arrested person for the purpose of giving such information, and also to the designated police officer in the district. The police officer shall inform the arrested person of his rights under subsection 1 as soon as he is brought to the police station. Any entry to the fact as to who has been informed of the arrest of such person shall be made in a book to be kept in the police station in such form as the state government may by rules provide. Then, my lord, it shall be the duty of the magistrate before whom such arrested person is produced to satisfy himself that the requirements of subsection 2 and subsection 3 have been complied with in respect of such arrested person. Then, my lord, if you come to the notice 48 also, my lord, I have annexed at page 22, 53, my lord. Here also, my lord, the same thing has been written, what has been informed to the, my lord, the arrested person.
You arrested him.
She was arrested on 9th of April.
Mr. Chaudhary, prior to this, whether any other application was filed for bail? No.
Not before Honorable Guwahati High Court.
No.
Before the, my lord, trial court, this is filed.
Prior to 25th of April?
That order, my lord, I have annexed also, my lord.
No, there is only one application there.
Yes, yes.
Prior to this?
Prior, it is not done as per my information. I am not sure, my lord.
Can you get this information, Mr. Waterford, from the concerned investigating officer?
I will try to get it, man. Yes, good enough. Yes, ma'am. Yes, there is one bail petition. Who is that? Yes.
Itu besok no. Itu na. Itu no. Itu 250 no. তো আগৰ petition কথা কৈছে তুমি এইটো 174 25 তাৰিখৰ আমাৰ লাষ্ট অৰ্ডাৰ হৈছে
अच्छा 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 तो फिल्म लगाए थे ना वो दिखता है
I don't remember any other bill application was filed earlier on.
yes man yes man 174 5 174
To my next progress. I have a next thing.
No, that is there prior to this. That's the reason why.
Yes, yes.
Yeah, you can give the information. Let us know by Thursday or Friday.
yes
Whether prior to this, any application of
Petition
yes
right? Because even if we call for the records, you will have only records of this case number 69,
yes yes
nothing else.
yes
Jorat PS case number 174 you mentioned.
In the case there, it will not be there. That application of for bail will not.
Yes, that will not be. That will
be
not be.
available on
Yes.
for the next special there. Get the information. I
Yes.
will know
yes on Friday man
because these are special cases and that's why the NDPS cases, you have the public prosecutor. Get the concept. When?
on Monday man
Already, my lord, 48 days in
That's the
custody.
reason we want to have this.
yes Friday man Friday
Okay, Friday.
Let me hear Lordship. Here in this case, Lordship, the petitioner is seeking bail on two counts, Lordship. First, Lordship, that
Advocate for restoration is not.
first is that, Lordship, that no grounds of arrest were communicated to the arrested person in terms of Article 22(1) of the Constitution, Lordship. And second, Lordship, on merit also, Lordship, that victim and informant already examined, Lordship, and victim says, Lordship, there was no physical relation between the victim and the accused, Lordship. And first of all, Lordship, may I kindly see that notices and arrest memo I have enclosed, page 36. The 37 is the arrest memo. And in notice also, it is only that page 39, that PS case number and sections are mentioned, that he is arrested. And if your Lordship sees the FIR was lodged on 13th belatedly after 3 days, and he was arrested on 25/7/2024. And no grounds of arrest is mentioned as to how he is connected in the present case, Lordship. And whether this notice will be sufficient or not, your Lordship's order is there, and if I am placing there. Your Lordship's order in passed in BA number 683 of 2025, Lordship. Those issues are clearly mentioned by in the said order. And in Mahbubul Haq's case also, your Lordship has categorically held that informing grounds of arrest is in addition to those notices, Lordship. And in my case, Lordship, no other grounds were communicated in the present case, Lordship.
Lordship, I want to place one judgment also.
Just a
Facilitate. Facilitate.
What do you have to say with regard to the evidence of the victim? Evidence of the victim. Ms. Das.
Victim in his lordship deposition. Lordship, he has integrated lordship and 164 also corroborated lordship.
Oh, in her post, she has said something.
It's 29. Yes, lordship. First, it in I gave my statement before the close and it was tutored by my village person.
Yes, what you have to say? Yes. Any reply?
In Lordship, proceed denied Lordship.
You have the, you have gone to the report.
Yes, my Lord. Medical report, Lordship, no evidence of injury as well.
Yes, it is fine. Six, 8 months. So. Sorry, I'm not concentrating for the petition. Status validation for the prosecutor appearing for this reason. Also heard Mr. S. for counsel appearing for the informant. What do you have to say, Mr. Paul?
Lordship, as per the cross-examination statement, your lordship, as he has denied, but it's up to your lordship.
All right, counsel appearing for the opposite party number 2. Elder brother of the minor victim girl. Informant with the case. Petitioner namely certain successful case of petition. Praying for his way. Well, the petition gets it. In POXO case number such and such. Rising up such and such. The trial of which is presently before the Court of London Special Judge POXO Monica. In which the petitioner was arrested on 27/07/2024 and in custody. Mr. Ahmed Leonard Counsel appearing for the petition. Submitted. That he is no way connected with the case. And even the victim girl in her evidence before the Court of London Special Judge POXO Monica indicated that there was no physical relation between her and the accused petition. And that because of love affair with the accused petitioner, she went on the day of the incident on her own with him. Mr. Ahmed, counsel appearing for the petitioner further the filing an additional affidavit placed before the court that while arresting him on 25/07/2024, the concerned investigating officer of Moirabari PS case number 110/2024 did not comply with the provision of section 47 of the PNFS as required under the law, and thereby violated the provisions of Article 22 of the Constitution. There is the reports of special POCSO case number 120/2024 along with the records of Moirabari PS case number 110/2024 that were called for by order dated 21/01/2024. As for the affair of the case, lost by the elder brother of the victim girl, respond number 2 hearing. The case is that on laws on 13/07/2023, The case is around 10/07/2024 at night around 2 p.m. when his younger sister, was at about 16 years, went out to attend the nurse's call. The accused petitioner forcefully took her away by showing her a desert and kidnapped her. But later, when they came to know that the accused petitioner kept his minor sister at Sotian Toli, they went there and recovered her. And her and his sister informed them that the accused petitioner had raped her against her will. In the said affair, in the date 13/07/2024, the informant also stated that about 2 months prior to the said incident, the accused petitioner also raped the minor victim girl, threatening her of dire consequences. The said affair was accordingly registered as Moirabari Police Station case number 110/4. No. While it was sent to the office of the public prosecutor.
On 28/4/24. So not updated. No. But only, my lord, regarding the present Mustaqin Ali, his bail bond is there in the case.
It doesn't matter.
Yes, sir. I will get it.
The investigating officer of Muradar Public Police Station case number 209/2024 shall submit the up-to-date case diary on 12th of June, failing which the said officer has to personally remain present before this court at 10:30 a.m. Mr. Pathakur, note it down and inform.
Yes, sir.
Till then, the petitioner shall remain in interim bail in said Muradar PS case number presented to him earlier on 10/4/2025. No representation on behalf of this petitioner, applicant on call. So, name of the council has been reflected on the first list. Forty-eight will call, no? 56 of the city. Council sleeping. This is the third occasion on which is the continuously on the third occasion the applicant remain unrepresented. Earlier on 14/02/2025 and 24/04/2025, the applicant remain unrepresented, but stands dismissed for non-prosecuted. Look at Hollywood. Where did it come?